So you asked before lunch whether the same criteria about safety, efficacy and quality applied to a consideration of a renewal of a license under the 1968 Act,
yes,
as they did in consideration of the original license. The short answer to the question is that yes, they do. That can be found in section 24, and particularly section 24.4 of the 1968 Act, which says that when a renewal application is being considered, section 19 of the Act applies. And Cynic, if we could have up, please, RLIT 40691, page 11. This is section 19 of the Act. And so that you have the exact statutory language, sir, we can see section 19.1 says that subject to the following provisions of this part of the Act, in dealing with an application for a product license, the licensing authority shall in particular take into consideration the safety of medicinal products of each description to which the application relates, the efficacy of medicinal products of each such description for the purposes for which the products are proposed to be administered, and C, the quality of medicinal products of each such description according to the specification of the method or proposed method of manufacture of the products, and the provisions proposed for securing the products as sold or supplied will be of that quality. And so, Nick, if we could expand, please, and go on to 2. And this is the point about when you can take efficacy of another product into account. In taking into consideration the efficacy for a particular purpose of medicinal products of a description to which such an application relates, the licensing authority shall leave out of account any question whether medicinal products of another description would or might be equally or more efficacious for that purpose, provided that nothing in this subsection shall be construed as requiring the licensing authority, in considering the safety of medicinal products of a particular description in relation to a purpose for which they are proposed to be administered, to leave out of account any question whether medicinal products of another description, being equally or more efficacious for that purpose, would or might be safer in relation to that purpose. That is what I tried to summarise earlier, sir, in, I hope, slightly more user-friendly languages about when you can and can't take the efficacy of another product into consideration.
Yes. Yes, thank you.
As I say, sir, that applies both to renewal and to the original application.
Yes, the criteria don't exclude cost being a consideration, but they don't mention it, and they give primacy to those 3 points.
Yes, a good cost comes up somewhere else. So it's section 20 deals with the point about costs, which is that the licensing authority cannot refuse a license on the grounds of price and cannot make a license provisional on the product being sold at a particular price.
So licensing authority could make it a requirement of the license, could they, that the licensed party informed those who were to receive the product that there was a that the information would be given to the public that there was a safer product manufactured by the same company at a different but a higher price.
I can see no reason why that couldn't be made a condition of the license. They could, of course, one of the ways of doing that would be to specify as a condition of the license,
yes,
or as part of the negotiation which leads to the final license, that in your product sheet you put a statement to that effect. And we will go on to see in some of the evidence that we look at this afternoon a specific requirement being made by the licensing authority about a particular statement that should be placed either in a data sheet or on a label. So that is an option that is open to them. What they can't do is fix the price.
Yes. Thank you.
One further document, so before we move to heat-treated products, could we have on screen, please, Sir Nick, HCDO 40403. I'm grateful for this having been brought to my attention. This is the minutes of the 8th meeting of the Haemophilia Reference Centre, held 6th of April 1979 at St Thomas's Hospital. We can see those who are present, Professor Blackburn in the chair, and then names that will be familiar to you and those who are watching this. If we could turn, please, to page 2, the bottom of page 2, item 5. The minutes record this. Concerning factor 8 concentrates, cryobilin, supplied by Immuno Limited. It was pointed out that the company was now selling cryobilin factor 8 at 2 prices, the cheaper preparation being made from American plasma. The implication is that the cheaper product carries the higher risk of plasma viral hepatitis. This has worried some of the directors. Professor Ingram has been in contact with Mr. Berry of Immuno, who had said that their action was aimed at making available to clinicians material which may carry less risk of transmitting hepatitis. There was then some general discussion about the price of factor 8 and the fluctuation in prices.
Well, I think that expression of the reason for providing 2-priced products was that it was to make available the safer product, though more expensive, as opposed to the inference from the German document translated, which was that it was exactly the other way around. It was Immuno seeking to give or put on the market something which was cheaper because, well, it was riskier from American plasma, but their main object was not safety, it was cheapness.
Yes, sir. I would agree with that analysis. The other point...
And if that's right, if Mr. Berry had been properly informed, and if it's properly reported that what he said to Professor Ingram, it's almost deceptive. I don't know about the almost.
There's no evidence that Mr. Berry, that we have, that Mr. Berry was informed of those Immuno AG documents. We simply don't know whether or not he was aware of that discussion.
Yes.
What we can say from...
But he is making a claim for what the purpose was.
According to this minute,
yes.
Yes.
If he's reported properly and accurately, that will be so.
The other point that I would make, sir, is that the application that was made to the licensing authority, if we could have it on screen, please, Sir Nick, MHRA 003321_085. If we could, so this is the application to change to allow American plasma. And if we could go down to the reasons, please. It is possible to sell factor, so this is the stated reason as part of the application to the licensing authority why they are seeking this change. It is possible to sell factor 8 concentrates produced from plasma of US origin at lower prices than European-based material. Because of the preference in the UK market for this lower-priced material, we also wish to make it available. Packs of cryobulin from alternative source material will be of clearly distinguishable colour, etc., etc. And we will continue to make available European as well as the proposed new concentrate derived from American plasma.
Yeah.
That is the stated reason. And if we could go, the signature has been, for obvious reasons, redacted on this version. I have a version which seems to be signed by Norman Berry.
By Mr. Berry?
By Mr. Berry.
Yes.
That's the 11th of November, 1976.
Thank you. Well, I think it would be in the public interest to remove that GROC cover.
So we will make arrangements for that to be so. Of course, if any core participant wishes to raise any objection,
Of course. I'll listen to any objection there is to that course.
I turn now, sir, to the issue of heat treatment. So, Nick, can we have on screen, please, SHPL 4068_070. We can see this is a note of a discussion from the 24th of November 1984, so we've come forward a few years in time. Present are Dr. Eibel, Dr. Schwartz, Mr. Berry, and others, including Mrs. Deenhofer. This is a meeting in which the heat treatment of cryobulin was discussed. If we could turn, please, to the second page. Sorry, the fourth page. Under the heading Virus Inactivated Coagulation Products. This states Dr. Schwartz tried to give a survey of the various heat and steam inactivation procedures. This is what I alluded to earlier, so the different types of treatment which were available as of November 1984. We can look at them here. TIM2 is the dry heated treatment, 10 hours, 60 degrees Celsius dry state. TIM3, 10 hours, 60 degrees Celsius dry state. I pause there to note that although those details are the same, there are other ways in which the two methods differ. TIM4, 10 hours, 80 degrees Celsius dry state. NeoTIM2, 1 hour, 60 degrees C, 200 mbar. That is a reference to it being steam or vapor heated under pressure, and the 200 millibars is the pressure. NeoTIM3, 5 to 10 hours, 60 degrees Celsius, again under pressure. And NeoTIM4, 1 hour at 80 degrees at 250 millibars, and 10 hours at 60 degrees at 200 millibars. So those are the different ways in which Immuno were seeking viral inactivation in their products. Different times, different methods of heating, different temperatures, and in one instance, a different pressure as well. This applies to cryobulin, but it also applies to the other products that we will consider in due course. What the meeting then goes on to say is this: as to methods TIM2 and TIM3, as well as TIM4, these are the dry heated treatments, we may run into difficulties with respect to patent protection. There exists a Hyland patent for this kind of inactivation. For methods NeoTIM2, 3, and 4, we have already applied for patents. As Mr. Berry explained, it will be essential to amend our product license applications to introduce inactivated products if we do not want to lose the British market. Lane, that's reference to Dr. Lane of BPL, promised that products that have not been virus inactivated will not be used after April 1985. Bloom, that's Professor Bloom, also stated that he will no longer use any products that have not been inactivated after his stock has run out. It was decided that, for the time being, data for cryobutyl TIM2 should be submitted to the authorities in order to maintain our market position and to achieve a slight price increase. The document then goes on to discuss ways of heating fibre and Pro-Thrombolex. If we could turn then to SHPL 5067_028. A letter dated the 26th of November 1984, so 2 days after that meeting where the discussion was taking place about the viral inactivation techniques. It is a letter from the DHSS, and particularly from Dr. Mary Duncan of the DHSS, to Mr. Nicholson, that's Robert Nicholson of Immuno Limited, the British company. What it says is this: Dear Mr. Nicholson, heat treated factor 8. Following our recent telephone conversation, may I confirm that the licensing authority wishes to encourage all companies involved in the production of factor 8 to use a dry heat treatment process in the course of manufacture. We are inviting each company to consider this proposal and, hopefully, to make early abridged application for a new product license. I look forward to hearing from you in the near future. This is in the context of the understanding that had developed during the autumn of 1984 that HTLV3 could be inactivated by heat treatment. So we can see there are discussions taking place within Immuno AG and between Immuno AG and Immuno Limited, and also encouragement from the licensing authority, the Department of Health, to put forward applications for dry heat treated licenses. The following month, December 1984, Immuno applied to change the cryobulin product license to introduce a heat treatment step. And that was said to be done, quotes, to reduce the risk of transmission of viral diseases. They proposed renaming the product Cryobulin TIM2. In a letter dated the 18th of January 1985, the licensing authority required Immuno to confirm in writing that the data sheet for Cryobulin TIM2 would include a statement that the product had been heated for 10 hours at 60 degrees. I pause there, sir, to say that this is an example of the types of requirement that the licensing authority can make in terms of how a product is presented to those who are using it. That was agreed by Mr. Berry on the 23rd of January. The variation application was approved on the 7th of February 1985. So we can see November encouragement to make license applications for dry heated products. The license application goes in December 1984, and it is approved on the 7th of February 1985. So that there on the transcripts, the references are MHRA 003320_066, SHPL 0000271_021, SHPL 0000271_020, and SHPL 0000271_011. An insight into the way that the process was working at this time is provided by a document that was sent on the 8th of January 1985. And could we have, please, Sir Nick, MHRA 0019502. This is a letter which is sent from Dr. Duncan Thomas of the National Institute for Biological Standards and Control, the head of the Blood Products Division, and we've heard his name a couple of times today. And it's sent to Dr. Duncan of the Medicines Division. the same woman who had sent the letter that we have just looked at in November encouraging applications for heat treatment. This is what Dr. Thomas says. Dear Mary, heat-treated factor 8. Thank you for your letters of December the 18th and the 27th, 1984. I've now had a chance to look at 3 sets of data relating to this product, provided respectively by Miles, Travenol, and Immuno. While all 3 companies are currently heat-treating their factor 8 and appear to be producing a satisfactory product, there are marked discrepancies between them in relation to the temperature and length of time for which the product is heated. The other obvious discrepancy is in the extent to which the companies have used marker viruses to assess the efficacy of their heat treatment. For example, Miles Laboratories have used 5 marker viruses and heated for 72 hours at 68 degrees Celsius. In contrast, Immuno used only 1 marker virus and heated their product for only 10 hours at 60 degrees Celsius. Travenol studied 4 marker viruses and heat-treated their product for 72 hours at 60 degrees Celsius. Just to add to the confusion, I learned yesterday that all Scottish-produced factor 8 is now currently being heated for 2 hours at 68 degrees Celsius. I must confess that I find this all rather worrying, particularly as the licensing authority has decided to deal with this matter in-house and not refer to the committee for advice. On the basis of the data provided, I am most impressed with that supplied by Miles Laboratories, Co8 Cutter.
Most, or is it more?
More. Not only did they use several marker viruses, they also actually studied the effect of a heat treatment on 2 of the 3 AIDS-related viruses, LAV and ARV. If they find it necessary to heat to 68 degrees Celsius for 72 hours, one wonders why Immuno believe that they can get away with only heating to 60 degrees Celsius for 10 hours. While it seems reasonable to conclude that all the regimens of heat treatment reduce infectivity, particularly in relation to AIDS, one is very struck by the variation in quality of the data provided. In particular, I'm worried by the paucity of data provided by Immuno in relation to the efficacy of their heat treatment. As you know, we have looked at most of the heat-treated factor 8 in the laboratory and find no significant differences from the untreated material in relation to solubility, assay characteristics, evidence for neoantigens, etc. I hope these few comments are of some help to you in your deliberations. With all good wishes, yours sincerely, Duncan Thomas. We take from that, aside from Dr. Thomas's comments on the various products, that the license applications were being considered, as he put it, in-house by the medicines division of the Department of Health and Social Services, not being sent out to the Committee on the Safety of Medicines. We will no doubt hear further evidence on that. The context, of course, is the pressing need to do something in response to the risk of AIDS. Mr. Thomas's concerns about the quality of the data being provided by Immuno seem to have been shared with at least some of those in the company. And so, Nick, can we have on screen, please, SHPL 5048 _026. This is dated the 5th of March 1985, and it is a letter that is being sent from Mr. Berry as chairman and Mr. Coombs as managing director of Immuno Limited to Dr. Eibel and Dr. Swartz in Immuno AG. In respect of cryobuline, the letter says this: subject to minor alterations in title and direction circular, we have been awarded a product license modification. We have, however, been informed both unofficially and officially that the information submitted by us for this modification was most inadequate, but for the panic situation which existed to get everyone on heat-treated material as quickly as possible, we would have been turned down. They expected far better proof of inactivation with evidence obtained against 6, 7, or 8 different viruses. They wanted greater evidence shown by clinical evaluation of the product they wanted greater evidence shown by clinical evaluation that the product remained equally effective and with no increase in side effects. A little later, on the same document, towards the bottom of that page, Mr. Berry and Mr. Coombs go on. You will recall that on receipt of both of these amendments, this is referring to cryobilin and Profromplex, we phoned and complained about the paucity of information, but you insisted that you were providing all that was needed. It is obvious that the American companies were lavish in supply of detail, and our submission had compared most unfavourably. The nadir of our submission was the gamabulin product licence application. That was an immunoglobulin. Since then, our reputation for poor submissions has improved. In fact, endobulin has received a measure of commendation. The cryobulin, and especially the Profromplex amendments, have had a further adverse effect on our reputation. This is a comment which is echoed in later correspondence about concerns expressed by those in Immuno Limited about the amount of data, the amount of information that was being provided to support applications by Immuno AG. If we go a little further down the page, we see under the heading of pricing, on factor 8, they write, we have been endeavouring to get 14 pence per unit, but Armour Cutter and Alpha are selling at 12 pence. This morning we have learned that Hyland have re-entered the fray at 10.5 pence. We understand that you do not wish to reduce the price to us in order to protect your German business. If, however, these competitors decide to attack you in Germany with lower prices there, then there will be no business there, nor any in Great Britain. We are also losing established customers to Alpha, who maintain that their wet-heated method removes the risk of non-A, non-B hepatitis, as well as AIDS. This has the support of the Royal Free Hospital and St Thomas's, both of whom have used the material for 6 months on virgin patients without transmitting NA-NB. A paragraph below that says, when the ministry first contacted us concerning the issue of heated material, they made it clear that they were looking for dry heated products. They now say that this was merely to avoid severe losses if they had specified wet heated. It is our view, however, that they are embarrassed by the new claims for wet treated material and are trying to avoid a position where they backed the wrong horse. Alpha are, however, selling this material at 14 pence and are hoping to increase their price to somewhere between 15 pence and 20 pence. So that's a reflection of what was being communicated between Immuno Limited and Immuno AG at that time. In a letter to doctors on the 11th of March 1985, Mr. Nicholson notified them that Immuno could supply heat-treated cryobulin, which would henceforth be known as cryobulin heat-treated. So not TIM2, the name it was given was cryobulin heat-treated. The reference is PRSE 302530. Moving forward to October 1985, there was discussion within Immuno about proposing changing the viral inactivation method from dry heat treatment to what was then described as steam heat treatment. A fax from Immuno AG to Immuno Limited stated that this was both because test results showed superior HTLV3 inactivation through the use of steam treatment and I quote, for reasons of patent law. The reference is SHPL 5050_013. And you will recall, sir, from some of the documents that we looked at earlier, that there was a concern that there wouldn't be patent protection for dry heated treatment, but there would be potentially for steam or wet heated treatment. For cryobulin, it was necessary to get a variation in the existing license in order to provide a steam treated factor 8 product, because the license specified the dry heat method. And the reference of that is SHPL 5050_011. It may help at this point to go to a document which shows which products were available when in the UK and on which basis. So, Nick, can we have SHPL 5066_001?
I'm sorry just to ask you to pause for a moment, because I'm just thinking about what you've just told me about SHPL 5050_011, which was that it indicated that the Immuno would have to show that the wet-heated cryobuline was superior to the dry-heated.
Yes, so it's in order to get the variation of the license, there was an expectation that you would have to explain why it is that you're now varying this license, which you obtained just some 8 to 10 months earlier. And that would require them to show that the steam-treated method was superior, or certainly the phrase superior was used in the document. But
I'm just, in my mind, puzzled by the comparison between this application having to show that the varied product was superior and the variation earlier on as to which we were discussing just before lunch and immediately after, as to the variation of source material for the product, where no such requirement seems to have been mentioned.
No, sir.
From what you've shown me from the Act, it's not a requirement as such to show that a product for licensing is superior to a previous product.
No, so I think this was an expectation within Immuno Limited about what they were going to need to demonstrate based on their knowledge of how the process worked. It wasn't a mandatory...
So it's a form of practical reflection on what they saw or thought was happening, which may or may not be right.
Yes.
Yes, I see. Thank you.
The document that we have on screen now, we can see, is sent from Immuno AG to Immuno Limited, sent to Mr. Coombs. It's dated the 20th of December 1989. It attaches a list of all copies of cryobuline and Profromplex texts. We'll come back to this document because it helps us to understand how the warnings developed in the data sheets. But at the end of the file, at page 80, please, Sir Nick, we have a fax which was sent the other way from Mr. Coombs to Immuno AG. It again refers to pack inserts, and it comes from November 1989. And it is seemingly a list of the products that were available on the UK market when they were available and the status of those products. We can see for cryobuline, the non-treated product, which was licensed, was available until December 1984. The dry-heated cryobuline was supplied on an unlicensed basis between December 1984 to March 1985. That ties in with the dates we've just been discussing. Then cryobuline dry-heated licensed, supplied from March 1985 to December 1986. And then cryobuline tin 3 steam, so this is a steam-treated product, unlicensed, supplied from October 1986 to date. The date of that is November 1989. And without wishing to give away the next step in the story, that shows that while Immuno retained a license for dry-heated products in the UK, they did not, in the 1980s, have a license for steam-treated products, despite the applications that we're going to come on to discuss. But this document appears to show that was nonetheless supplied, presumably on a named patient basis, possibly on a clinical trial basis. The first application to switch to steam treatment was made on the 5th of March 1986. The reference is MHRA 00333320_040. The pharmaceutical assessor raised several points on receipt of the application and raised them with Immuno. And these included a request for further information on the moisture content and the steam treatment process. And it was noted that the assessor was not convinced that steam treatment offers any advantage over dry heat in terms of viral inactivation. Reference is SHPL 5065_028. The Committee on the Safety of Medicine Subcommittee on Biological Materials assessed the application in July 1986. They considered that they were unable to recommend the variation on the grounds of quality and safety and requested further information about the process and justification of the steam treatment. And they also noted, and I quote here, "The term steam treatment is a misnomer and is unacceptable." The reference is MHRA 00333320_044. The application was rejected on the 11th of July 1986, SHPL 40271_008. We will come back to the terminology, steam treatment or vapor treatment, when we come to look at the packaging. Immuno prepared a variation application to change to what was now termed a vapor-heated product after getting that rejection. The reference is SHPL 40141_220. In a memo, which is at that reference, it was stated that it was essential that we obtain the Cribulin license amendment as soon as possible, as we are now no longer able to apply for Factor VIII contracts due to the fact that we do not have a licensed product. The variation application, next variation application was sent in a letter on the 23rd of December 1986. The term used was vapor-heated product. It was a Method 3 product, so a TIM 3, steam TIM 3 product. It was differentiated from the March 1986 variation, which had been unsuccessful. And Mr. Berry said in his submissions to the department that the proposed changes would introduce into the UK, in his words, the most rigorously treated Factor VIII concentrate currently available from Immuno. He stressed that the product for which the license was sought was totally different in terms of heat treatment and viral inactivation profiles from that which had been rejected in March 1986. He stated that the concentration of HTLV3 was reduced by 6 log steps after vapor heating for 3 hours, but to ensure an even greater level of safety, in his words, it was heated for a further 7 hours. The reference is MHRA 00333319_017. And so the sum total of that is that the product was heated for 10 hours at 60 degrees Celsius in the presence of moisture. The variation application included information that the donors were tested for antibodies for HTLV3 using FDA-approved tests. And it was stated, and I quote here, actually, so can we have this on screen, please? MHRA 33320_006. That's now, I'm sure people will now begin to recognise this as a variation application form, and you can see that the reference to vapor-heated Factor VIII Method 3. If we could go, please, Sir Nick, to page 3 of that. This is what is said about the underneath the heading Precautions and Warnings. The careful selection of donors and plasma and the vapor-heated treatment process, which has been shown capable of reducing artificially introduced HDLV3 by 6 log steps, suggests that in the light of present knowledge, the transmission of HDLV3 can be excluded. The above measures will certainly reduce the risk of transmission of viral hepatitis. This is being demonstrated by the fact that upwards of 20 naive patients have been followed up by ALT tests for 4 months and have not acquired NAMB infection. But transmission of hepatitis cannot be entirely ruled out. So that is what was said, or proposed to be said in the warnings, were an application to be granted. The application was considered by the CSM Subcommittee on Biologicals in July 1987. Nick, can we have up, please, MHRA 00-33319_044. You can see that the subcommittee recommendation was that on the evidence before them, the subcommittee on grounds relating to quality and safety were unable to recommend the grant of a variation of a product license for this preparation. I won't go through all of the points which are raised as to why they came to that conclusion, but I would highlight point 12, which is on the following page, Sir Nick. There was concern regarding the transmission of hepatitis B by this product. There was also a remark to the company from the subcommittee. In view of the number and importance of variations contained in this application, a fuller and clearer list of where changes in production and quality control standards and procedures should have been given. So again, a complaint about Immuno not providing sufficient information to back up the applications. Mr. Coombs from Immuno Limited wrote to Immuno AG on the 20th of July 1987 to relay the fact that the variation was going to be rejected and to give details of conversations he had had as to why it was going to be rejected. One of the things that he said in that letter is that the subcommittee were currently looking at products heated at 80 degrees for 72 hours, and therefore products heated for 10 hours at 60 degrees were looked upon with great suspicion. They know that dry heated products at 60 degrees for 30 hours have caused seroconversion in the United Kingdom, which I take to be a reference to factor rate. We'll come on to that in due course. The references are SHPL 40141_151 and SHPL 40141_158. There was a meeting between representatives of Immuno Limited and Immuno AG and members of the licensing authority to discuss the variation applications, not just cryobilin, but also Prothromblex and Theba. That took place on the 12th of August 1987. Immuno undertook to withdraw the applications and agreed to submit an abridged product license application for cryobilin, including expert reports. The reference MHRA 0033319_040 and SHPL 40141_136. The formal rejection of the application came on the 16th of September 1987. References MHRA 0033321_021. I'm not going to go through those documents, but the references are there, and if people are interested in how the licensing process worked and the way in which discussions took place between representatives of the company and representatives of the licensing authority, those documents provide some insight into that. A further application an application to renew the existing dry heat treated license was made on the 3rd of March 1988. Now, the submission that accompanied the application pointed out that the dry heated product was no longer sold in the United Kingdom, and Immuno were currently preparing data for an abridged license application for a vapor heated product, which they hope to sell instead. The references are MHRA 003319_001 and the same stem _002. The point here, sir, is that they have a license for a dry heated product. Even though they're not selling that product in the UK, they want to maintain the license so that they can then apply to vary it to produce the steam treated product rather than starting from scratch and putting in a new license application. And it should be noted that the licensing authority were made fully aware of the fact that this is the approach that they were seeking to take. So, Nick, if we could have on screen, please, SHPL 40141_097. The situation as of 7th of July 1988, as we understand it from the documents that we have looked at, is that Immuno Limited were still providing UK clinicians with a cryobulin product. It was a steam-treated product, the only one that was available in the UK at that time, but it was an unlicensed steam-treated product, so presumably was being provided on a named patient basis, possibly on a clinical trial basis. What is said in this letter to Dr. Schwartz is as follows. We have been informed this week that the regional haemophilia directors in the UK have sent a circular letter to all haemophilia centres informing them that only Factor VIII products to be used in the UK are as follows, in order of priority. 1. Factor VIII-Y from BPL. 2. Hemate-P from Behring. 3. Prophylate from Alpha. A customer of ours who has constantly been in touch with us to establish when we are going to obtain a license has contacted one of the regional haemophilia directors in response to this letter and has been informed that if she uses unlicensed products, then she will not have any backing from the haemophilia directors and must take sole responsibility for its use. She is, therefore, now having to decide whether to change to another product. We will have to be very careful that this situation does not extend to FEBA, as this currently provides a very important part of our turnover, FEBA being a different product. So we could see that steam-treated cryobulin was still being provided, but there were concerns amongst Immuno Limited that its market share was diminishing rapidly. There are further letters. I won't go through them all. I will give the references in a second. The general tenor of which is Immuno Limited contacting Immuno AG, urging the need to sort out license applications and to get a license in order to protect market share for cryobulin within the UK. The references are SHPL 40141_086, a letter dated the 27th of September 1988. SHPL 5010_005. And SHPL 40106_165. That final reference contains a note from Mr. Coombs to Immuno AG saying that their current licenses could be cancelled, and these are his words, if the DHSS realised that cryobulin and FEBA are dry heated and Prothromplex is non-heat treated. So he's concerned about the cancellation of those licenses. It should be added that the dry heated cryobuline was not being sold, even though the license still existed. There was the abridged product license for cryobuline was made on the 24th of May 1990, so some time after those initial letters. The reference is SHPL 5068 _001. This was again referred to as a Method 3 product. So that application was made on the 24th of May 1990. The next correspondence we have, which is relevant to the licensing, comes from the 30th of April 1991, so nearly a year later, and it is from the Medicines Control Agency, who, as we know, have taken on the work of the Medicines Division. And that renewed the existing cryobuline heat-treated license. So we understand that to be a renewal of the dry heat-treated product. That is SHPL 5067 _001. The application to vary that license to a vapor-heated product was considered by the Committee on the Safety of Medicines on the 27th of June 1991, and on the 8th of July 1991 they informed Immuno that they were unable to advise the grant of a product license on grounds relating to safety and quality. The reference is MHRA 00345575 _058. Several reasons were cited, including concern over the transmission of hepatitis B and non-A, non-B hepatitis, and it was said, quotes, the risk-benefit ratio was unacceptable. Mr. Coombs subsequently wrote to Immuno AG on the 31st of July 1991. The reference is SHPL 40106 _094. What he said in the letter was, and I quote, "I suspect that 6 log steps is no longer acceptable to the licensing authorities, and we will not be able to show a significant improvement from dry heat." And he noted in the letter that by contrast, another product, Monoclate, was claiming a reduction of HTLV spiked virus by over 15 log steps. So the concern is expressed by Mr. Coombs in this letter, in effect, that the viral inactivation method that Immuno were seeking to have licensed compared unfavourably with those that by that time were on the market and being considered by the licensing authority, and he thought that they were going to have great difficulty in getting a license. There were further meetings with the Medicines Control Agency, SHPL 40106 _080, in which there was a discussion about why the Medicines Control Agency were reluctant to grant the license. I won't go through it. People are invited to consider and read it again, as it shows an insight into how this works. But to sum it up shortly, it's fair to say that the MCA were not persuaded that vapor heating was effective. They said that there was a spectrum between, on the one hand, dry heated products at the lesser end of effectiveness, and what was referred to as pasteurization, so that's heating in a solution at the other end, which was safer. And the MCA considered that steam treatment was, vapor treatment was somewhere in the middle, and they couldn't quite place where on the scale it was. And that was one of the reasons why they were not allowing the application. As we move into 1992, I won't go through all of the correspondence, but there was a decision taken that the cryobuline heat-treated license should be given up, and an acceptance that there was no way that they could be used in the future by Immuno Limited, and an acceptance, it seems, that the steam-treated product was, or sorry, the vapor-treated product was not going to get through the licensing authority. The references are SHPL 40148_001, SHPL 5067_006, and SHPL 5067_005. The licenses for cryobuline heat-treated and indeed for Profromplex were cancelled by the MCA on the 14th of April 1992. That is the story of cryobuline. It's been slow going, but hopefully, having seen some of these documents, there'll be no need to go back to them, and there'll be a greater understanding of how the process works, so we'll pick up some pace, I hope, going forward. I am about to turn to Profromplex. I'm conscious of the time. I don't know if you wish me to continue or to take a break at this stage.
Well, if it's a convenient moment to take a break, yes, we'll take a break till 3:20.
Thank you, sir.
Make it 25 past to allow people time. 25 past.